Hello and welcome to the big picture. In an unprecedented verdict, the Supreme Court today quashed the decision of Arunachal Pradesh Governor Rajkova to advance the State Assembly session in December last year and restored the Nabam Tuki-led Congress government. Delivering the verdict, a 5-member bench of the Apex Court made scathing remarks against the actions of the governor and the way he had conducted himself. The verdict also reflects on the centre, which had gone on to impose president's rule on the state and later withdrew it before a government led by a Congress rebel, Kaliko Pul, and supported by BJP members was installed. This verdict to the Supreme Court has many important aspects which will be of importance in future both politically and constitutionally. We will today look at the implications of this verdict and what far-reaching consequences it will have. To discuss this, I have with me P.P. Singh, former Governor and Home Secretary, Government of India, P.D.T.Achary, former Secretary General, Lok Sabha, Prashant, Bhushan, Advocate, Supreme Court. Welcome to all of you. Mr. Singh?
Yes.
When you look at this judgment, what are the consequences of this kind of a action which has been taken, and now the Supreme Court, restoring and also quashing the actions of the governor? How does it reflect on the office of the governor?
It makes me sad, both as a former Union Home Secretary and as Governor of Sikkim, that the governor chose to act in a matter that he could not have acted independently. It was incumbent on him that if the assembly session has to be preponed, he was required to consult the Council of Ministers. And he had earlier fixed the date in consultation with his Council of Ministers. Now, having done that, I sometimes wonder that there is a public perception that the governor had special powers. Now, the governor of several states, including Sikkim, of which I was the governor, has special powers, but that is also let down. And under Article 163 of the Constitution, the governor has to act with the aid and advice of the Council of Ministers. I looked at Article 371H again, which gives the special powers to the governor of Arunachal Pradesh. And there also it provides clearly, in simple English, that the governor has special powers in respect of law and order, and there too he will exercise his discretion only after consultation with the Council of Ministers. Now,
So he has no powers which can be seen as being away. Keeping the Council of Ministers away.
no, he didn't have discretion in this matter at all. But in matters of law and order, he has discretion to go contrary to the advice of the Council of Ministers.
Can go contrary.
But here, he has no such authority. So he must not confuse, no person should confuse the discretion of the governor under Article 371H with the discretion of the governor to act under Article 163.
Okay, sir. We are now joined in by Soli Sorabjee, former Attorney General of India. Welcome, Mr. Sorabjee. Mr. Sorabjee, is this some kind of an unprecedented judgment? Because some people are saying that this is a very rare judgment. Some are saying it's an unprecedented judgment. What is this? What do you think this is, and what are the consequences of this?
Law is always laid down by unprecedented judgments. Look, the judgment is recognized that the governor has to act within the limits of the Constitution. And the judgment, I have not read in detail, but the conclusion seems to be that he bypassed the Council of Ministers in summoning the Assembly.
Right.
Now that seems to be a rather strong point. He could not have done that. And in any case, the whole question is, now the judgment is given. Now what will happen thereafter is a point to be seen.
Yes.
Because even now, if any person challenges the majority of the Chief Minister, that will have to be determined by a floor test
Exactly.
in the House,
Right.
not in Raj Bhavan.
Right.
So I consider the judgment as an affirmation of constitutional principles by the Supreme Court. It's a bold judgment without regard to any political consequences or which political party it affects. And I think it restores the faith of the people in our Supreme Court, particularly in restoring or preserving the federal fabric of the Constitution.
Sir, this restoring of the government, which has not, it has not happened in the fashion that it has happened now. You think that, will it send message to the governments in future that this power which the Supreme Court has exercised here is something which cannot be played around with?
Yes, that's quite right. Supreme Court judgment has to be obeyed. Otherwise, again, the Supreme Court will interfere if they disregard it in other cases, other similar cases.
Okay. Mr. Achary, this,
Yes.
how do you look at this judgment? From the time what happened in December till the Supreme Court heard the case till in February it reserved the order. After it reserved the order, there was a new government which came into existence.
A lot of wrong things have been done there. And the Supreme Court has come very heavily on the governor. We all know what happened during that period. This judgment, which has come today, I would say it is in line with the Bommai's judgment. Because in Bommai's judgment, Supreme Court had said in appropriate cases, the Supreme Court has the power to restore a government which was deposed unconstitutionally.
It had not happened before.
It had not happened before the way in which it happened today.
Yes.
It has been done today. And then since this has no precedent as such, so we do not know. Now, the Supreme Court has said the earlier government
Status
stands
quo ante has to
restored.
be restored.
Restored. Now, how it will be restored and what exactly is the procedure which has to be followed, these things are not there is no clarity in those things because such a thing has never happened.
How do you compare this with what happened in Uttarakhand?
In Uttarakhand, actually, the point is the Supreme Court, through an order, asked the Chief Minister to take a floor test.
Yes.
Okay. He took the floor test and then he was restored as Chief Minister. But the Supreme Court had actually not given a judgment on the basic issue being the constitutionality or otherwise of the presidential proclamation.
Right.
That is the thing.
But here, even the presidential proclamation has been. Can you say that the presidential proclamation has been challenged or quashed?
It is not actually precisely on the presidential proclamation. It is actually the governor's actions.
Right.
The governor's action in convening or advancing the day to the assembly without the aid and advice of the Council of Ministers, because he is supposed to do that. The governor on his own cannot convene the assembly. Governor does it only on the aid and advice of the Council of Ministers. Without the aid and advice of the Council of Ministers, he can't do that. So he did it. And that has been commented upon adversely by the Supreme Court,
Okay. Prashant, does this verdict of the Supreme Court reflect on the presidential proclamation also?
Yes, certainly it reflects on the presidential proclamation because the presidential proclamation was based on the illegal advice of the governor. The Supreme Court has held that the governor's advice to impose president's rule on the ground that the constitutional machinery of the state cannot be carried on in accordance with the constitution, which conclusion was based on two things: that the Speaker did not heed the governor's directive to convene the House on a particular date which he had preponed, and secondly that the Speaker had disqualified certain MLAs the Supreme Court has said that that is not a correct basis for the governor to act and say that the government cannot be carried on in accordance with the constitution, and therefore that really was something which the governor did along with or at the behest of the central government. So therefore it is clearly an indictment not just of the governor, it's an indictment of the central government also, which sought to misuse its powers under 356 in order to basically replace the government through the process of president's rule, which is what they did. In fact, if you look at the crux of this issue, what has been happening is, the same thing happened in Uttarakhand also, that the central government used the help of some defectors of the Congress governments in order to topple the government, impose president's rule, and thereafter form a government, try and form a government with the help of those defectors. Now, that renders completely nugatory the Anti-Defection Act, because under the Anti-Defection Act, if some people defect, and that's what the High Court held in Uttarakhand, that those defectors have to be disqualified and their votes will not be counted.
Right.
In the Arunachal Pradesh, they have not said anything about the, all that they have said is that the speaker ought not to have disqualified these people when a motion for his own removal was pending.
Right.
And in any case, the speaker's order has been stayed by the High Court. So now the matter will go back with the previous government restored, and possibly the motion for removal of the speaker or the motion of no confidence against the government will have to be taken up and voted upon. There the whip of the Congress party would prevail over those MLAs who have defected, and if they vote against the whip, whether it is on the motion for removal of the speaker or on the confidence motion, then they are liable to be disqualified.
Okay.
But unfortunately, what has been happening, what we have been seeing is an attempt to just throw away the Anti-Defection Act and install another government with the help of defectors.
Mr. Sorabjee, would you agree with that? Would you agree with Prashant's argument and then about the reflection on the center?
Yeah, I'm in substantial agreement, because if the action of the centre was based on the governor's report, which was not correct, then naturally the basis of the president's rule is also affected. To that extent, I agree with him. But the whole question is now, what is going to happen?
Exactly.
There can be two things. There can be another motion or resolution to say that the present government which has been restored doesn't enjoy majority. That will have to be tested again. But it has to be floor test.
Right.
And a proper floor test on the floor of the House. So this is a little complicated situation. But basically, I agree with Prashant, that does affect even the imposition of President's rule, because it was based primarily, if not solely, on the basis of the governor's report, which the Supreme Court has found to be totally illegal.
Okay. Okay, sir.
Governor's action, rather.
Okay, we are joined in now by Siddharth Varadarajan, founding editor of the Wire.in. Siddharth, what next? There's a lot of complications now which have cropped up. The judgment itself seems to be an unprecedented one. So what next is also, there are a lot of complications there.
Well, I think there's, what next involves two separate spheres of action. In many ways, the easier one, even though Mr. Sorabjee is quite right to suggest that there are complications, is to guess what will happen next in Itanagar, where Mr. Nikam will have to be sworn in and will then be given time to prove or establish his majority on the floor of the House. And depending on how either the rebels are cajoled back into the Congress camp and all is well that ends well for the Congress party, or they act as defectors and the anti-defection law is triggered. The more difficult question to answer is whether the BJP at the center, and here I would say Prime Minister Modi himself, BJP President Amit Shah, and the legal brains trust of this government, Mr. Arun Jaitley, are willing to accept now that evidence is piling, that they have acted improperly in two instances, Uttarakhand and Arunachal. They've played fast and loose with constitutional proprieties. They have influenced or suborned governors to act in this way, or governors are, or individuals who have no appreciation for the Indian Constitution have been put in these positions and have been acting in an illegal fashion. It's this big question that the central government and the Prime Minister and his closest advisors need to ponder over.
Okay.
Because, having been reproached twice now, it's very clear that the party's approach...
What is it that the central government can do now?
No, I'm saying
it has to accept the judgment.
It essentially has to, for the remaining duration of its tenure, it has to now introspect and undertake not to try to hasten the process. It's all very well. I think it's admirable for the BJP to say that we want a Congress Mukh Bharat, or for another party to say that they want to rid a country of another party. But there is a political process that has to be followed. You can't short-circuit that.
Mr. Singh, if you were the governor today, and after this judgment, how would you go about restoring status and the status?
I just would like to say that this is a very classic case of establishing the supremacy of rule of law.
Right.
All orders were passed by competent authorities, but that was ruled by some decree or misunderstanding, including the proclamation of the President's rule. So that way, the Supreme Court needs to be applauded for making it very clear that the rule of law shall prevail. Now, having said that, in that backdrop, the governor has to immediately first appoint him, invite him to start
the
functioning.
process.
Yes. And then once he does that, then he should be advised, and in consultation with his Council of Ministers, to give him a date for the assembly session. And that is the only way, a quieter way, a decent way for starting the new democratic process in terms of the orders of the Constitution and of the Supreme Court. I have not read the whole judgment. Maybe that the Supreme Court has given some direction as to how to proceed further in the matter.
I don't think, Prashant, is there if you have gone through the entire judgment, or if you have heard about it, is there any direction given to the Supreme Court as to how to go about now?
No, I don't think so. No.
Okay.
No, I don't think they have given any
Okay.
direction.
Okay. Mr. Achary, how do you think you can go ahead now? What happens really? There some of the complications, for instance. There was on 15th of December, which the Supreme Court is talking of to restore the status quo ante. By some MLAs had been disqualified or suspended by then government, and then later 14 MLAs were disqualified. What happens to all those things which was there? And the present Chief Minister who is there was a Congress rebel. He has formed his own party. Now, are all of them going to be treated as, because there are 47 Congress legislators out of it in a house of 60. So will all those 47 who are now not part of the Congress, they have separate party, will all be treated as Congress members?
See, I must admit that there is not much clarity in the situation. The Supreme Court, of course, I have not read the whole judgment, but now it is clear that, as Mr. Prashant Bhushan has said, that Supreme Court has not given any indication as to how to go about it. Now the point is, once the Supreme Court gives its judgment, it comes into effect. All actions have to follow in accordance with the Supreme Court's judgment and direction and all that.
Conformity.
So the restoration of the government of December, the government which existed on 15th of December, that is the first thing that has to be restored. And the present government...
That means Nabam Tuki has to be invited by the governor, told to take oath.
In fact...
And probably given it...
No, in fact, the point is, there also, there is a little lack of clarity whether he has to be administered oath by the government again, governor again, or whether he automatically becomes, because of the force of this judgment, he automatically becomes the chief minister. Because it is a restoration.
Right. That's what the word used is restore.
Yeah, administering oath means it's a new government.
Exactly.
Okay. Then the present government, because many questions are being asked as to what happened to this government, whether the government exists now or not. That means when the previous government has been restored, this government has no existence at all. That means it has gone out of existence because of this judgment. And then what will happen after the government is restored? That, of course, has been dealt with as Siddharth, Varadarajan and Mr. Prashant, Bhushan. The floor test has to be done to clear.
Because, there was a motion for floor test, a motion of no confidence actually at that time.
So, the floor test has to be held to prove the majority of the government. And after that, things will become clear once
after
the floor
that,
test
once
is done.
That floor test. Mr. Sorabjee, that first we'll have to wait and watch now how the governor will go about, about his task now. But my question, another important question which has cropped up, because this happened second time in the last few months, the accountability when it comes to these kind of actions, these kind of judgments which are given by the Supreme Court. Is there has a time come now for us to talk about issues of accountability? I want both you and Prashant to first you, Mr. Sorabjee.
Well, the whole question is adhere to constitutional norms. You can't just dismiss governments for extraneous reasons, and that's the main thing. And I think the Supreme Court judgment, though it may not give directions, I think certain consequences follow from the judgment, and they have to be complied with. And I think it will be really very odd if any government, in spite of the Supreme Court judgment, tries to act in a manner to circumvent it. Yes, after the government is restored, have a protest, let the majority prove one way or the other, that's understandable. But not by saying that so-and-so will again have to be administered oath and this has to be done. This is not the way to really advance our democracy. You can't play with the anti-defection law in this manner.
Okay. Prashant, how do you look at the whole issue of accountability?
Yeah, you see, in these matters, the Supreme Court can do only what they have done. They can't go further than that and issue some order punishing the governor or punishing the central government, etc. The indictment of the Supreme Court is a political punishment of the central government and the governor. However, what it does underline, this judgment and this repeated misuse of President's rule, underlines the need to have some independent authority deciding whether there is a constitutional breakdown in a state or not, and could be some election commission type of authority or some other independent authority. You can't leave that decision to a partisan central government which is a political player in this whole game, which has a political axe to grind, and who controls the governor. The time has come for us to think of independent governors who enjoy security of tenure, who are appointed by a non-political process, and who are not subject to removal at the whims and fancies of the central government. And the time has also come for us to think about whether this imposition of President's rule should be left to some independent constitutional authority and not to the central government, which has a vested axe to grind.
Mr. Sorabjee, what Prashant is suggesting will require a complete change, several amendments to the Constitution. But that is one thing. The second thing is, do you go with Prashant on that?
What independent constitutional authority? I want to know what is the independent constitutional authority.
It could be like an election commission.
What is it? What will it constitute?
Election commission type of body.
No.
Anyway, sir, this is a matter which I'm sure there can be more debate on. But there is one more question, Mr. Sorabjee. there is already an indication by the present Chief Minister that he may go in for a review petition. Is a review petition of this judgment possible? If you were the Attorney General of India today, would you have recommended it to the government?
I don't know what will be the grounds of review. I haven't read the judgment. But I don't know, review can't be an appeal from the judgment. Review can be if some provision of law has been overlooked or there's a manifest error of law. You can't review a judgment, go for review because it doesn't suit you. The judgment must have finality. It's only in rare cases that review is allowed.
Prashant?
No, there is no chance of succeeding in a review in this matter. It was heard ad nauseam over a period of many weeks, and they have delivered an exhaustive 331-page judgment. They have considered every issue which was before them, and therefore there is no question of any review being allowed against this judgment.
Okay. Siddharth, what are the lessons because this whole thing happened because Congress, despite having an overwhelming majority in that assembly with 47 members in a house of 60, managed to mess up things because of the rebellion, revolt which happened there. So what are the lessons for the Congress, apart from what are the lessons for the BJP also?
Look, the Congress needs to introspect because Uttarakhand and Arunachal were both products of its own political mishandling, I would say incompetence, because leadership is all about spotting dissension and managing contradictions within your own fold and doing so in good time. And it is clear that the Congress leadership at the central level had ample warning of the storm that was brewing in Itanagar and either chose not to act or took a series of wrong decisions which in a way created fertile ground for the BJP acting through the instrumentality of the governor to do what it did. Politically speaking, the judgment is a ringing indictment of the governor's attempt to play politics, right? The judgment says clearly that it's not for the governor to pick and choose who will be CM and to arrange assembly sessions and instruct the speaker or deputy speaker accordingly in order to produce a political outcome that you want. That's not what the role of the governor is. That's certainly not what the Constitution envisaged when the post of governors were created. And I think that this is a valuable lesson that has much wider implications beyond Arunachal. This is something which, the point Prashant made that governors, I'm not sure if independent governors is possible under our present political or constitutional arrangement, but as long as governments at the center look at governors as pure political appointees and not just, in fact, it used to be that you rewarded a political person, which was fine as long as they didn't do any damage. But if you're going to go one step further and actually get them to push certain political agenda or to rework certain arrangements, I think that's a very, very dangerous and slippery slope.
Okay, Mr. Singh, very quickly.
I think the answer lies in having people of integrity, high reputation, independence of mind as governors. So the real question is whom you make a governor.
Okay. Mr. Achary?
Well, we can try other methods, as has been suggested by the other panelists. Certainly, the system of appointment of governors, has left much to be desired. But that is what the consequences.
That's what the consequences of this judgment and also the Uttarakhand has shown us. Anyway, on that note, we'll end. But this is a very important day in our constitutional history, probably, which will in future the governments will have to think twice before taking any such action as far as the state governments are concerned. Thanks to all my guests. Please keep watching. We'll come back with another issue in the big picture same time tomorrow.